Hi everyone, I can see that it's straight up at 4 o'clock here in Paris time, and this is the International Water Resources Association webinar on legal mechanisms for water resources in practice. We're going to go ahead and start in about 2 minutes. Everyone, both my panelists and the audience, can make any predictions and get yourselves ready. We'll be starting in just a minute. Thank you for tuning in today. Okay, everybody. Well, it's 4 o'clock here in Paris, and we're going to go ahead and start the International Water Resources Association webinar on legal mechanisms for water resources in practice. As you know, this is a webinar hosted by the International Water Resources Association. The IWRA is an international network of researchers and practitioners who work on multidisciplinary range of water resource issues. It's a nonprofit, non-governmental educational organization, and the IWRA provides a global knowledge-based forum bridging disciplines and geographies by connecting professionals, students, individuals, and corporations and institutions who are all concerned with the sustainable use of the world's water resources. We're so happy to have you here today, and thank you for tuning in. We have a really outstanding, excellent panel of both academics and practitioners, all of who have many years of experience on this webinar's team of legal mechanisms. Many lawyers here amongst us. And I think, as many of you know, this theme for the webinar kind of grew out of a very close collaboration that the IWRA has with AIDA, the International Association for Water Law, and the presentations that they had at our World Water Congress in Edinburgh, Scotland. I know many of you, myself, were there in Scotland and really enjoyed the presentations. And a lot of those presentations were expanded on in the special issue of Water International, our flagship journal. And so if any of you hear something that you find very interesting, you can go to the journal's webpage and download the articles and find out more and really read in depth on these issues that are being presented, and to see some other articles which we're also in the special issue but aren't being presented here today. And these issues will also be in the subject of our upcoming policy brief. So please be look out for that in the very near future. And finally, if there's anything here today that really sparks and you want to keep the debate and the discussion going, we're going to be following up on our LinkedIn webpage to kind of provide a forum for people who are interested in continuing to discuss these issues. So go ahead and go to our LinkedIn page and follow us, and then after the webinar I'll have a little area where you can register and say what you want to say, and we'll have a discussion, and it'll be very interesting. So without further ado, our panel is quite experienced, and we have Marcella Nanni from the International Association for Water Law, Sarah Hendry from the University of Dundee, Helle Munk Ravnborg from the Danish Institute for International Studies, Laura Pateiro from the University of Vigo, and Tignino from the Geneva Water Hub. I don't know how many of you have tuned into our webinars in the past, but we're going to follow along with the same general format that we've had in the past. which is that each of our presenters will give a short PowerPoint presentation of about 10 minutes. And then afterwards, we will have time for questions. And if you'd like to direct your questions, you can see on your GoToWebinar dashboard, there's a section that says questions about halfway down. Go ahead and click on that tab, and you can just type in your question, and I will see it. And then you can make it clear if you want your question to go to one particular person, a couple of people, if you think the question sort of bridges between different presentations, or if it's something very general that you want to hear the whole panel weigh their thoughts in on. Go ahead and type the question, and then when it's time for those at the end of all of the presentations, then I will go ahead and moderate those questions and ask them for you. So without further ado, we're going to turn the floor over to Marcella.
Okay, thank you, Scott. I'm very happy for your invitation to participate in this webinar. And I think this webinar is very important because, well, this special issue focuses on contributions by AIDA members who look at legal issues in a manner which is not academic, but is informed really by experience on the ground. Scott, let me know whether everything is all right with the audio, because I'm experiencing some problems.
Yeah, the audio is fine, but the web, I can't see your webcam at all. Could you turn your webcam on?
No, in fact, yeah, because otherwise I deactivate my audio. Now,
well,
let's
didn't have
try.
Really.
Well, I'll try. Let me know whether everything is okay with the audio, please.
Everything looks fine, yes.
Okay, because it might be interrupted at any time.
Okay, well.
Anyway, starting from AIDA, for those who do not know the association, but I guess all the participants do know the association. AIDA is its acronym in Spanish. It is the International Association for Water Law, created in Washington, D.C. in 1967, and precisely on the 30th of May during the Water for Peace conference, when the need arose for an NGO to provide a forum for matters relating to water law. Initially, the association was dealing with domestic water law, but then it expanded its scope to international water law. So the purpose of AIDA is to foster the evolution, the study, and the understanding and the application of water law, both within national and within international contexts. As we know, legal mechanisms for the management and development of water resources have evolved over time to address quite a number of challenges that derive from well, growing water demands for various purposes of use, the recognition of the importance of groundwater, scientific and technological progress, which makes it possible to improve the knowledge of water resources through the relevant tools, modeling, GIS, etc., etc., but at the same time facilitates development, which may lead to water resources depletion, water quality degradation, and also environmental problems, and in some cases to conflict. Let's think of big mining projects, which are made possible by technology, new technologies such as fracking, hydraulic fracturing that has an impact on groundwater, and other technologies. As examples of big projects, big mining projects having an impact on water resources, I may quote the Reko Diq project in Pakistan that is likely to affect also Afghanistan and Iran, or the Pascualama project which involves basically the taking and the removal of parts of glaciers that feed water resources which are transboundary and affect Chile and Argentina. Other challenges relate to environmental degradation, climate variability, which requires the introduction and implementation of adaptive tools. Then there's a challenge arising to the need to provide access to safe drinking water and sanitation. And this requires improved services, water supply and sanitation services, and some mechanisms to control the quality of the services. Sarah, in a while, will show the example of Scotland, that is being in one form or another replicated in other countries. Of course, not all the countries are in a position to introduce successful tools because, well, the matter of implementation is a very important matter. Creates a lot of problems, especially when the institutions are not able to deal with the issues. All these and other challenges have determined a gradual shifting from a piecemeal approach to water legislation, that is, legislation dealing with one issue, laws on water supply, laws on hydropower, laws on fishing, on other issues, then pollution control, and so on, to a more comprehensive legislation until to reach really more sophisticated legal tools. Present water legislation in general tends to acknowledge the interdependence of water, whether surface or underground, and other natural resources, all within the context of river basins, and tends also to provide for planning tools. Water legislation also, while placing water resources in the public domain, tends to provide for secure water rights and mechanisms for allocation and reallocation, which are somehow responsive to changing needs and to the need to deal with uncertainty and to the vagaries of the climate. Of course, the success of water rights systems will largely depend on the capacity to implement the system. Helle will show in a while the manner in which attempts at implementation of water rights systems have taken place in the case of Nicaragua. Water legislation also tends to contemplate minimum flow requirements or water reserves to satisfy basic human needs and environmental requirements. Also, the greening of water law tends to provide linkages between water legislation and environmental protection legislation through also the requirement for environmental impact assessment. Water legislation also contains provisions specific to groundwater, which aim at groundwater protection through the setting of protected areas and the control of drilling operators, among other things. Legislation also provides for economic tools in support of efficiency in water use and water protection. It also tends to enable public participation in decision making. The importance of stakeholder participation in decision making in relation to the allocation or reallocation of water resources, particularly in a changing climate, has been highlighted by Eric Garner in his article, which is also contained in this special issue on the adaptation of water laws to increasing water demand and changing climate. Unfortunately, Eric Gardner is not with us, but it's really a good article. Finally, water legislation tends to recognize customary water uses. International water law, because we don't have, we cannot forget the international dimension, also pays increasingly attention to these challenges, particularly in light of the fact that development may create, yes, a potential for conflict, but also opportunities for cooperation. Mara will also, in a while, highlight the examples of Senegal and Niger in the management of infrastructure, and particularly the example of joint infrastructure in the case of the Senegal River Basin. Mara will also discuss the green elements of the legal frameworks for these two basins, and also participatory approaches. The recognition of the need for states to cooperate in the management of transboundary groundwater resources, as we know, has triggered codification of the law of transboundary aquifers, and now we have draft articles on this subject, which were adopted by the ILC in 2008. And the UN General Assembly has issued a number of resolutions to invite states to take them into account while drafting their respective agreements or arrangements. In a few minutes, Laura will briefly discuss existing international agreements and arrangements on transboundary aquifers, which are very few in reality. I think we have now around 8 and not all in force. And Laura will also carry out a reflection on the prospects for future cooperation on transboundary aquifers. I would like to mention other articles which are contained in this issue of Water International, which are those of Michael Kidd on the compulsory licensing under South Africa's National Water Act. There is also an interesting article by Rhett Larson on governing water augmentation under the Watercourses Convention. He evaluates how the Convention's principle of reasonable and equitable utilization governs the impact of technological innovation, with particular regard to desalination and cloud seeding. He proposes the interpretation of international water law principles, those provided for in the Convention, in the light of new technologies. Finally, the special issue contains an article by Shanna McLean, Carl Brook, and Sylvia Secchi, which is on adaptation in the TITSA, innovation and tribulation at the sub-basin level. And this article focuses on the manner in which the regime, which has been constructed for the Danube River Basin, is implemented in the TITSA sub-basin. As we know, we are talking about the Danube regime that involves 19 countries. And now we go down to the TITSA sub-basin with only 5 countries, and all countries, let's say former socialist countries, including a country of the former Soviet Union, which is Ukraine. It is a very interesting special issue, and as I mentioned, really provides an overview of challenges with concrete examples on the ground. And now I would like to leave the floor to the colleagues who will discuss specific contributions to the issue. That's it.
Well, thank you so much for that, Marcella. That really gave us a great overview, I think, of where this presentation is going to go, and really what the special issue and many of the presentations in the Edinburgh World Water Conference were all about. So we're going to go right now to our first presentation. It's Sarah Hendry. And just a quick reminder to all of my panelists, we're aiming for about 10 minutes for the presentation, and that way we'll have about 30 minutes for questions afterwards. So I don't want to have a gong show and pull you off, but keep an eye on the clock if you could. Thank you. Sarah, the floor is yours.
Thanks, Scott, and many thanks for the invitation both to be part of the special issue and also to be part of this webinar. Are my slides showing, Scott?
Yes, the slides are showing. There you go.
Excellent.
Perfect.
Thank you. So my name is Sarah Hendry, and I work at the University of Dundee in the law school and also with a specialist centre looking at water law and the interaction of water law, policy and science. And I would start by making the caveat that I am well aware that Scotland is a small jurisdiction, developed country, complex administrative provision, and we have a lot of water. Anyone who's ever had the pleasure of a wet holiday in Scotland will know we have a lot of water. And therefore, lessons that we've learnt here are not necessarily applicable to other jurisdictions which have a more significant resource management issue. Nonetheless, we have gone through a lot of changes in the last 15 years or so, and it might be that some of the lessons that we learned and some of the activities that we went through in reforming our water services provision might be of interest to other people as well. And on that basis, I presented around our public sector provider, Scottish Water, at the Edinburgh Congress that Scott mentioned, and that was also the subject of my paper for the special issue. So Scottish Water is it's a public corporation. It's owned by the government. It does, however, have most of the features of a corporate entity. So it's not a municipal entity and it's not a government department. And in the period of time from the quite early 1990s, but certainly from the late 90s through to the present, we've undergone the usual kind of sets of administrative, policy and regulatory changes that are familiar in many countries around the world. And Marcella noted that many countries have gone through something similar to the journey that we've gone through, and hopefully there will be some resonances here for people in the audience. But I hope that what we've experienced here in Scotland has been a story that you'll find worth telling. At an early stage, we moved from being a municipal service provision, as was the norm in most countries, to a single dedicated entity providing water and sewerage services to most of Scotland's consumers, not all, but most. And initially the move was made to 3 regional authorities and then to a single national authority, national entity, this public corporation. And that move away from municipal provision happened as an alternative to the divestiture, the privatisation process that we saw in England and Wales. So when water services in England were divested to the private sector, that didn't happen in Scotland. For a variety of reasons that didn't happen. There was a lot of public opposition to it, and instead these regional authorities were set up, and then in 2002 they were amalgamated into a national body. And the principal reason for the amalgamation was an economic one, that prices were going to be rising quite rapidly to account for the investment requirements mainly coming through European water law, and therefore there would be economies of scale in having a single provider. And as part of that shift, we brought in a system of economic regulation, which in many regards is very similar to the system that was brought in England and Wales for the divested utilities there, not just water, but being applied here to this public entity. And over 10 years and more, that regulatory model, in my view, has been hugely successful. There was a set of so-called performance measures, operational performance measures, that were essentially comparable between Scotland and the English water companies that were set up after 1989. And compared then to our English counterparts, Scottish Water moved from quite seriously underperforming right down at the bottom of the heap to as good as the best, routinely in the top 4. And also, and equally importantly to my view, what we have reached now, 15 and more years later, is a situation where the public provider is making an active contribution to the achievement of wider policy goals, not just in terms of drinking water coverage, sewerage coverage, but also in terms of wider environmental goals, water management goals. So it's an important part of a governance model that I think has demonstrated its successfulness over a period of time. For the lawyers in the audience, just a little bit on the regulatory framework for Scottish Water. So in the blue box in the middle, we have what I would describe as a broad approach to economic regulation, looking not just at the level of tariffs as against service standards, but also looking to achieve social policy objectives and environmental standards, and ensuring that all those requirements can be met by the tariffs that are levied. The government sets the policy framework and the mandatory objectives for the service. We have an environmental regulator, SEPA, which deals with abstraction licences and discharges of wastewater. We have a separate drinking water quality regulator, applying drinking water standards under European Union law. And then we have the economic regulator, the Water Industry Commission. And that commission is an independent regulator, so it's quasi-independent. It sets charges in a 6-yearly period. And it also licenses our retailers for business supply, and I'll say a bit more about the retailers shortly. So, a number of pieces of legislation, the details probably not of much interest, but the core duties in the Water and Sewerage Acts, the Act setting up Scottish Water in 2002, and an important Water Environment Act in 2003, another one in 2013, putting some new duties on Scottish Water about maximising the value of the resource. But the broad economic model in 2005 in the Water Services Act. And what the Water Industry Commission does in conjunction with the other regulators and working within this government framework is to ensure that Scottish Water can provide the service, achieving all of its mandatory objectives, and there's a detailed technical specification for that, and what's defined in the statute as the lowest overall reasonable cost. And the lawyers will immediately note that that word reasonable then indicates that there's some room for discussion, some room for tailoring beyond the mandatory objectives. And another part of that regulatory mix that isn't in the slide as such, it's not a regulator as such, but is involved in regulation, was the Customer Forum, which was set up just a few years ago in 2011 in order to try and bring a better customer perspective into that price setting process. So the regulatory framework, I would say, has been successful and has enabled the regulators to drive up standards, whilst maintaining prices at, generally speaking, that reasonable level. No commentary on water service provision or the legislation surrounding service provision would be complete without thinking about the public-private debate. I've mentioned already that Scottish Water remained in the public sector, but nonetheless there are some aspects of its operation that might be categorised as the kind of thing that a private entity would also do. And there are also two elements of private sector participation in the system here. So on the one hand, Scottish Water is public, but it's commercialised. It's expected to fully recover its costs. It has a full system of accounting for its assets, its infrastructure, the service it provides. And I think I would stress that that is not privatisation. That in itself is just something that service providers of complex utilities should be able to do. We also have some licence competition around retail services for business customers. So not the actual supply of water or the actual removal of wastewater, but around multiple billing, around multiple utilities, for example. And although that's been at relatively small scale, it's been, on the face of it, successful. Scottish Water has a retail arm which competes, and the regulator considers that the competition has, again, driven up service standards and kept costs down for the business sector. Perhaps more importantly, certainly as a matter of scale, we have a number of wastewater treatment plant which were built under PPP contracts at the end of the 90s and into the early 2000s, again to meet European Union investment requirements. And while many listeners will agree that PPP is not necessarily the cheapest way over the lifetime of the plant to supply the service, and we probably wouldn't do it again as these contracts come up for renewal, nonetheless they have operated successfully. And to my mind, it's a good example of the need for a little bit of nuance. The public-private debate is heavily polarised, and we need to try and limit that a little bit as academics and practitioners, and to recognise that there are situations where the private sector will be involved, will make a contribution, will play a role. And that does not need to mean that the service has been privatised or that the service is being privatised in a general way. So to finish up with some of the lessons that we've learnt, I would say that it takes a while for the regulatory process to mature. The first two rounds of price control here were really quite hostile, really quite a negative relationship between Scottish Water and the regulators. But that's changed. That's changed partly as a result of that data collection exercise. It was difficult to obtain the data that was necessary to regulate effectively, and it was difficult to verify that data, and disputes over the data did cause some hostility. But without a doubt, what we did find here was that it is possible to regulate the public sector into private sector efficiency. That can be done. And we did it here, and I think that's an important lesson for anyone who is seeking to reform their service provision in a way that keeps it in the public sector, but nonetheless makes it more efficient, reduces some of the inefficiencies that the public sector as opposed to the private sector might be prone to. Of course, there are also inefficiencies in the private sector, but that's not the subject today. I think, though, one of the interesting things for me, up until not very long ago, I was fairly defensive about this, having to try and defend Scottish Water, defend what we'd done here, as against a lot of people working in England who might take the view that privatisation, divestiture had been more successful. I no longer feel defensive like that. I think that one of the things that I've seen here in Scotland is that when you have a mature regulatory system and a public entity, it's easier for that public entity to contribute effectively to public policy goals. And I would say that at the moment we're in a good place in Scotland, what you might say was a high point in our regulatory cycle, where the government, the regulators, the service provider and the consumer bodies are all working together to provide an excellent service in a service that is still public. Thank you. Anna.
Well, thank you for that presentation. That was really helpful. I thought that was really insightful, and I really appreciated the nuance that you brought to the discussion of what, like you said, it's so often very polarized, take it or leave it, very emotional debate for many good reasons, but the nuance is very important, and I think it was good for you to be able to put that in the context and specificness of the Scottish experience. So thank you for that. Our next panelist is Helle Munk Ravnborg. So we'll go to you directly, and please make sure you unmute your microphone.
Like this?
Yes, excellent. Wonderful.
And do you see my screen clearly?
Yes, we do.
Okay, good. I just have to see my own screen then. Yeah. Like this. Okay. So I will present some work that we did on the implementation of the water governance reform in Nicaragua. Nicaragua, as you may know, is a Central American country known for a high level of inequality, and we were examining to what extent inequality has an implication on the results from this implementation of the water reform, and whether the result would be securing rights for people as the proclaimed objective of the water reform, or whether in fact it would be maximizing dispossession. So first of all, a few words about irrigation, because this, we have chosen to focus on the aspect of irrigation when looking at the implementation of the water reform. Irrigation is important these days for a number of reasons. It's important in the context of climate change, and it's also important in the context of socially and environmentally concerned markets. First of all, with respect to climate change, I think we all know, and probably you who are in Southern Europe these days sense it very clearly, that we have a very unpredictable and we also have a very variable climate coming, and with varying rainfalls. That has implications for food security and probably also a lot of implications for food insecurity. Food insecurity becoming a hot topic in many parts of the world, both at subnational and national level. And irrigation can do a lot in that context. It's estimated that supplemental irrigation can increase food production on average 43% in developing countries, and in Southern Africa to 300%. So irrigation, even if it's only supplemental, is becoming more and more important, both to small-scale farmers and for local food security, and also on the more global scale. In the context of environmentally and socially concerned market, irrigation is also important. In many parts of the world, a number of people and consumers are preoccupied with social and environmental footprints of production, and that, of course, includes irrigation. We have sugarcane as a case, sugarcane used for biofuel, growing in many parts of the world as a commercial crop. In Nicaragua, we have tobacco for cigars that uses, the growing of tobacco uses a lot of water that could otherwise often compete with water to be used for domestic consumption, or competes with water used for supplemental irrigation of food crops. So do we accept as consumers and as citizens irrigation to take place at the cost of those social aspects, and do we accept that irrigation takes place at the cost of the environment? And raising those questions have made then the formulation, or of course the formulation of conditions and standards also with respect to the use of water in order to regulate the footprints from a social and environmental view. For instance, if you want to obtain financial capital from the International Finance Corporation, you need to be able to document that you have legal access to water. For instance, if you want to expand your sugarcane production, if you want to sell in specific markets for high quality coffee or special tobaccos, you also want to, or you need to document that you have legal access to water and that you treat your wastewater well. If you want to join the UN Global Compact, now the UN Global Compact is formulating the water mandate. And so this regulatory framework for controlling social and environmental footprints is developing. So in that sense, it's important also for a country like Nicaragua to be able to regulate, to govern its use of water for irrigation. And now that was what many people thought for a long while, and there was a long process that I won't come into here for negotiating a new water reform in Nicaragua. With respect to irrigation, I think it's important to find out what is the context, what is irrigation in Nicaragua, what was the context where this water reform was to be implemented. And most people, I think, when they think of irrigation in Nicaragua, they think of large extensions of land, they think of sugarcane, flat areas being irrigated with technology as what you see here in the picture. Or this is tobacco being irrigated by gravity and furrow irrigation in the northern highlands of Nicaragua. But it's important to recognize that also irrigation is small-scale irrigation being carried out by persons like you see here in the picture for growing maybe half a hectare or quarter of a hectare of tomatoes, or for supplemental irrigation for some trees that you want to see coming out, or for some maize in this very sort of rustic type of irrigation system. And when we look at this in a map, we can see that there is a strong territorial dimension to the distribution of irrigation. If we look at the distribution of farms, this is a map of Nicaragua, and the distribution of farms that have irrigation according to census information, we find that most farms, in fact, there are about 12,000, a bit less than 12,000 farms in Nicaragua that has irrigation. 75% of those have irrigated areas of less than 3 hectares. And almost 2/3 of those are located not on the flat areas of Nicaragua, but in the slopes, in the hillsides. Whereas when we look at irrigation in terms of area, we see that most of the almost 80,000 hectares that are under irrigation are located at large farms, farms that have irrigated areas of more than 20 hectares. And 85% are located in the flat areas. So we see a stark contrast between the number of farms, the farmers who use water for irrigation, and the acreage irrigated. That territorial distribution reflects in many ways the level of inequality when it comes to the distribution of land and the ownership of land in Nicaragua. What you see here is a picture, a graphic that shows the PAMA ratio. That means the ratio between the 10% largest farms in a district. Each of these little units are districts. So the 10% largest farms divided by the 40% smallest farms. And the more red the color, the more unequal the land distribution within each district. And the more sort of green-blue, the less unequal. And what we see is that when we look at irrigation in terms of number of farms, most of the farms, that is the red bars in the graph, most of the farms with irrigation are located in the not so unequally distributed districts, or where land is not so unequally distributed. whereas most of the land under irrigation is located where land distribution is highly unequal. Now that is the context where the water governance reform was to be implemented. So what the water governance reform that was implemented with the law in 2007 was all about, at least in terms of irrigation, was that there should be a national water authority, and that was created 3 years after the passing of the law in 2010. It's located in the capital city. All water use should be authorized one way or the other, and the aim of doing that was to ensure a sustainable and equitable use of water and the conservation of the country's water resources. It should also enable the effective exercise of rights to access water. So a very strong social dimension and equitable and user-focused objective of the water governance reform. That also accounts for irrigation. So with respect to irrigation, there were two ways in which you could document your water right. Either you could obtain a concession with the National Water Authority, or you could obtain an authorization with the districts that had a cooperation agreement with the National Water Authority. According to the law, all farmers who had irrigated land of more than 20 hectares, they had to apply for a concession, whereas those who have irrigated land less than 3 hectares, they could do with getting an authorization from the local district. Now, the law was a bit silent with respect to what should happen if you had between 3 and 20 hectares. I guess that was an omission, but I think it's an omission that also tells that maybe in the preparation of the water governance reform and the law, there was very little view to the actual facts of irrigation and its application throughout the country. It was only in 2010 that the law was effectively regulated, and the regulation that came out in 2010 then changed the criteria for who should apply for concessions and who should apply for authorizations. Now, according to this regulation that applies today, it's all farms that are more than 70 hectares that should apply for a concession, or farms that produce for the industrial market, whatever that is. That's not further defined. And all farms that are less than 70 hectares and do not produce for the industrial market, they can do with applying for an authorization. Now, the big issue here is, of course, that nobody actually knows what the industrial market means, and so it's kind of difficult to find out who should actually apply for what. What we did was that we went through the National Gazette, the Nicaraguan Gazette, in order to identify all the administrative resolutions that were made in the period between 2011 and 2015. We characterized those and introduced them into a database. And then also we did archival research in the National Water Authority and interviews with a number of district authorities and other water-related authorities throughout the country. And what we find is that there's a very strong, and that's what I would like to highlight to you here today, a very strong political economy dimension of the way that the water governance reform was implemented. By the end of 2015, we had identified 433 administrative resolutions, most of which were published in the National Gazette, and 120 of those were related to water rights for irrigation. No cooperation agreement had been made between the National Water Authority and the districts, and that of course implies that the small-scale farmers, whom you remember were in the hills of Nicaragua, in the central part mainly, concentrated there, had no opportunity or no possibility for documenting, for legitimizing, formalizing their water access and thereby their water right. So what is taking place here? We are making the provocative question whether we actually, with the reform process, managing to regulate water use, or what we're actually managing to do is to provide a legalization service for those who need that. For instance, the large-scale sugarcane producers who need that legalization service in order to obtain capital for their operations, for instance. If we look at the number of farms who, according to the, no, I think I will not have time to go into detail with that, but what I will leave you with here is that if we look at the progress made today, is that about 120 concessions have been issued. If we look at the requirements established by the 2007 water law, that corresponds more or less to 1/3, 31% of the farms that should have asked for a concession, they have actually done so. Whereas if we look at it in the context of the regulation that was made in 2010, what it corresponds to is that 10% of the farms who should have asked for a concession have done so. It also corresponds to 1% of the land, of the water use, and by the land under irrigation. So that is what is making us ask the question, whether none of the small-scale farmers have actually managed to document, to legalize their water rights. So for those 10% of water users for irrigation who have managed to obtain a concession, they have obtained formally sanctioned rights, but they also have a position now where they're able to block the law on tariffs on water use for irrigation, whereas those small-scale farmers for whom it's unclear whether they need an authorization or a concession, and where to go in case they do need the authorization, that avenue is blocked for them simply because there's no cooperation agreement made, and they are left then in a legal limbo to a large extent. Now, what does that mean for water security and water insecurity? It means that there are territories in Nicaragua where water insecurity is growing because they are legally invisible. If you move into the registers of water rights, they will not be seen there because they lack rights and they lack ways of documenting their rights. It means then that those territories also, maybe not so much today, but as concerns and forms of documenting legal rights to water, as those pressures grow, they will be left with limited economic opportunities to compete in markets for certified coffee, certified tobacco, for obtaining credit from banks and finance institutions that demand such documentation of legal water access. And it reinforces the existing inequalities, both at the national level, but also at the subnational level. So giving priority to the flat, large-scale agriculture in the bottom of a district at the expense of the uphill, usually small-scale farmers. So it raises the questions and I think the challenges to us. And when we are concerned with water governance reform for very good reasons, it's not just a question about being concerned of the water laws and getting those ones right. It's as much a question of having a sharp focus on the importance of implementation. In Nicaragua, we have the trivial but very important situation of very limited staff in terms of numbers, maybe up to a maximum of 15 technical staff for doing this implementation. Now, that is a precondition to be taken into account. And of course, laws and administrative practices have to take that fact into account, but it's also a political choice. There's a reluctance to delegate, so the National Authority for Water has been very reluctant to to enter into these agreements with districts, and they have put priority to the concessions before actually making the cooperation agreements with districts that could benefit small-scale farmers. There have been limited operational resources. That means that one of the technical requirements for obtaining a concession is that a hydrological study should be made. Now, because of operational resource limitations, those ones are conducted by applicants or by consultants contracted by the applicants, and thereby also maybe steered by the applicants, rather than as independent studies. That means that water security becomes a new dimension of inequality that we have to be very concerned with, particularly as the importance of irrigation grows. And powerful applicants in need of legal services, they have, that's a potential for success. They have actually pushed for the implementation of the water governance reform because they need that legalization service. But it has also been a caveat because it has jeopardized the regulation in many ways. For instance, on the hydrological studies, there's no independence on that. And there's a very unfortunate mix between the formalization, or that the formalization has been taking place at the same time as the negotiations of the water tariffs is still ongoing. So powerful applicants have been in a position to influence the water tariff decisions, whereas the less powerful applicants have more or less seen it as convenient to remain and go below the radar, but in the long run, that means that they risk seriously losing their rights. So with these words, I want to thank you for your attention and thank you for listening.
Excellent. Thank you so much for that presentation. I think we all learned a lot, and I really appreciated how you sort of helped us shift from the urban, more urban or national context, perhaps, to a more specifically rural context, and brought forward those questions about inequality. But at the same time, at the end there, we were able to kind of go back towards questions about water tariffs and how those are set, which is some of the same things that we talked about in the first presentation with Sarah. We're going to go on to our next presentation with Laura, and I'd just like to ask my last two presenters to keep a real eye on the clock. We'd like to have some time for questions at the end of this, but I'd like to ask you to keep your presentations to a reasonable 10 minutes or less. And for anyone in the audience, if you'd like to ask questions, please remember that the box is right there on the right side of your GoToWebinar control panel, and that all you need to do is just type the question. I will see it and then ask it during the question period at the end of all the presentations. Thank you, and we're going to
Okay. So thank you, Scott. Good afternoon, everyone. Is all okay? Can you hear me? Yeah?
Sounds great.
Okay. So, sorry. Yes. Okay. So the title of the paper was Ad hoc Legal Mechanisms Governing Transboundary Aquifers, Current Status and Future Prospects. And the paper is based on the fact that at least 592 transboundary aquifers and groundwater bodies has been identified so far, and despite that, very few agreements and arrangements on specific transboundary aquifers have been made so far. So taking that into account, and also we are referring to those agreements and arrangements and as ad hoc legal mechanisms on transboundary aquifers. So taking all of this into account, the goal of the paper was threefold. I wanted to analyze the existing legal mechanisms on transboundary aquifers, to try to identify why there are so very few of them, and then to reflect on the future prospects of these legal mechanisms. So first of all, the paper analyzes the call for states to conclude agreements on specific transboundary aquifers that has been made by different international fora in the last years. For instance, within the UN system, we have this called in the United Nations Water Courses Convention on the resolution on confined transboundary groundwater of the International Law Commission, also on its draft articles on the law transboundary aquifers, and also in the resolutions related to those draft articles. And also we can find examples of that call in within the framework of the UNEC, of the United Nations Economic Commissions for Europe, both in the Water Convention and on the model provisions on transboundary groundwater. So therefore, there is a clear call upon the states to conclude those kinds of agreements and arrangements. But however, the states' response has not been very enthusiastic so far. Is it true that references to groundwater have increased over time, but surface water is still the main subject of regulation? But in the last years, we can find some examples of arrangements and agreements that has been concluded both by states and also at the local and federal level, and they can be bilateral or multilateral and so forth. But it's still a very few. There are still very few of these agreements or arrangements. So then the paper tried to identify those few existent agreements and arrangements, and it describes them very briefly, their origin, the content, and the background of these agreements. So the paper identified the Treaty on the Nevian Sandstone Aquifer System from 1992, then two informal agreements of 2002. It also identifies two informal agreements on the Northwestern Sahara Aquifer System that were concluded in the year 2000, also in the north of Africa. Also, we have two memorandums of understanding, one of 2009 and another one of 2014 on the Yuli-Medin to the Aquifer System in West Africa. We have, of course, the Treaty on the Guarani Aquifer that you probably know is not yet in force because not all the four aquifer states have already ratified it. And we also have a treaty signed between Jordan and Saudi Arabia in 2015 on the DC aquifer. Those are the examples of agreements concluded between states, but we can also identify some agreements concluded between local or federal authorities. Of course, all of this is not a closed list, but they are the agreement that has been analyzed in this paper. So we have at the local level, we have the very well-known agreement in 1977 on the Genevese aquifer between Switzerland and France that was renewed in 2007. And then we can find at least two memorandum of understanding at federal levels, one between the province of British Columbia in Canada and the state of Washington in the States of 1996, and another one between the city of Juarez in Mexico and the city of El Paso, also in the States, of 1999. So the paper then compares the content of these different agreements and try to offer some remarks, some conclusions based on that comparison. So, for instance, a geographical pattern is hard to determine. In most cases, these agreements are the results of projects with funding and assistance from international organizations. Their legal nature and status are quite different. Some are proper binding treaties, while others are informal agreements or memorandum of understanding. Also, the scope and content of these agreements vary considerably. Some of them are mostly technical, some are very simple, and others contain very detailed provisions, so they are quite heterogeneous. And then the paper tries to answer the question of why are states reluctant to govern their transboundary aquifers through this kind of agreements. So, of course, cooperation on transboundary aquifers faces additional challenges than cooperation on surface water. For instance, the remaining knowledge deficit on transboundary aquifers. There are still a lot of things that we don't know about many transboundary aquifers in the world. Sometimes transboundary aquifers are just not a priority for the states because there are not urgent problems relating to their exploitation, or there is plenty of surface water. Also, we need to remember that when we are talking about aquifers, we are talking about two elements. So, an aquifer is made of a geological formation and the groundwater that is in that geological formation. So it's a resource that because of that geological formation, has a special connection with the state sovereignty. So that may favor kind of unilateral actions on its management. And also, we also have a still unclear global legal framework to take as a reference when we are managing groundwater. So those can be some of the reasons why states are still reluctant to conclude this kind of agreements. And finally, the paper includes some reflections on the way forward. So in an idealist scenario, a step-by-step approach should be adopted, whereby knowledge is first acquired and then the focus shift to regulation and management properly. Transboundary aquifers seems especially prone to one-off solutions because of the different composition of the subsoil that each aquifer may have, also because of the different transboundary implications that a transboundary aquifer may have. Of course, the effectiveness of cooperation will depend ultimately, of course, of the will of the parties to fulfill those kind of agreements. But both treaties and informal agreements provide advantages in that cooperations. Treaties in general enhance cooperation, promote and reflect awareness of the particular circumstances of a transboundary aquifer. They provide certainty, they may provide an institutional structure, dispute settlement mechanisms, and so forth, so they can be very useful. And also, informal agreements have their advantages. They are simple, flexible, and have a low public profile, so maybe they can be preferable in certain circumstances. And also, local transboundary arrangements not between states, but between local communities, may be especially useful when the communities involved in the management or the use of that aquifer are mainly local. In general, the paper proposed a wider cooperative approach on the management of transboundary aquifer that should be encouraged by the international community. The paper argues that the precautionary principle in particular is called to play a very important role in this management because of the uncertainty that in many cases there is still on the futures or on the consequences of the ongoing exploitation of aquifers. And finally, it argues that this strategy will require and other factors, such as enhanced knowledge on transboundary aquifers and increase in public awareness of the benefits of cooperation and understanding of the consequences of not taking preventive or precautionary actions, exchange of good practices, and of course international funding. So that's were more or less the main ideas of this paper, and thank you very much.
Well, Laura, I really appreciate that presentation, and I think we all found that very interesting. I particularly highlights the important and often overlooked aspects of groundwater and aquifers. That's kind of coming to the forefront now, I think, in international water law, which is so long focused on surface water. And it's also very interesting, I thought, to really bring a highlight to not just the international state-to-state scale, but also the smaller ad hoc, like you said, between communities, which is a scale which is often overlooked, I think, in international law, but impacts so many people because we all live in communities, more or less. So we're going to go to our last presenter right now, and I'm going to again remind you that questions will be available with the last amount of time we have. So go ahead and put your questions there in the question box in the go-to panel control on the right side, and also ask my final presenter to try to keep it to a good 10 minutes or less if you can possibly do it. Thank you. With that, it's over to Maria.
Hello. Thank you, Scott, for sorry. So thank you, Scott. I would like to thank also the AIDA and the IWRA for having invited me. So it was really a pleasure to do this research on the Senegal and Niger watershed, and I would like also to pay a tribute to the Geneva Water Hub that gave me the opportunity to do a research for a conference that we have organized in 2015, and where the participants from the OMBS, the Organisation pour la mise en valeur du fleuve Sénégal, or Senegal River Development Organization, and the Niger Basin Authority participated. So the topic of my article is the joint infrastructure and the sharing of benefits in the Senegal and Niger watershed. So I will focus on particular on the common infrastructure. We will see the differences between the Senegal and Niger, and also this concept of sharing of benefits that it has already been analyzed by several scholars. So to sorry, I cannot. So in a first time, I will examine the legal framework on the joint ownership, and then I will try to show you how local communities and the environment have been included in the sharing of benefits. So we will see an evolution from an interstate dimension to a local involvement of the local communities. So this map, I want to show you the two different watersheds. The Senegal and Niger rivers are the first and second river of West Africa, and the Senegal is shared by 4 countries, so Mali, Mauritania, Senegal, and Guinea, and the Niger River is the third river in Africa after the Nile and the Congo, and it is shared by 9 states. So we can see already the difference between these two rivers, and there is also we can say a social difference, because in the Senegal river we have a French tradition. The 4 countries shared were under the French colonial power, and in the Niger basin we have different colonial powers. What is interesting, it is also that in the case of the two basins, the the emergence of the need to manage jointly the two rivers came up after the independence of these countries. Even if already at the end of the 19th century there was freedom of navigation that was given to was applied to the Niger River. So here you can see a picture of the Diama Dam on the Senegal River. This dam is situated in the delta of the Senegal River between Senegal and Mauritania. So what is the particularity between of these two dams? It is the fact that the Diama and Manantali dams are considered as common and indivisible property. Here I have included Guinea, but I should specify that Guinea acceded to the ONBS only in 2006. So it is not really we don't know how Guinea will benefit from these two joint infrastructure. So it is not important where a dam is located, if it is in the territory of one state, because in any part of the territory of a state, these dams will be considered as a joint property. So another interesting aspect, it is the fact that under the ONBS, two autonomous agencies were created to manage the two dams, and we will see in particular the two conventions that established these autonomous agencies for the Diama and the Manantali dams. And what is also interesting, it is that the three countries, because Guinea, as I said, only acceded in 2006, they agreed in how to share the benefits, but also how to share the cost. So what is the legal framework? We start in 1978, the convention concerning the legal status of common works, and we should say that legal agreements started already in 72 with the recognition of the international status of the Senegal River and the putting in the place of the ONBS. So in 78, we have this specific convention on common works. In 82, there is the aspect relating to the financial aspect, and we will see that there are some interesting features in this matter. And then in 1997, we have the two conventions that created the two agencies for the management of the Diama and the Manantali dams. So starting from the convention of 1978, as I said, there is the Diama and the Manantali dams are common and divisible property of the ONBS member states, and there is no exhaustive list of works that are designated as common works. So at this moment we have the Diama and Manantali dams, but also some port facilities that are managed jointly, but this does not impede that other works will be could be included in this framework of a joint infrastructure with benefit shared between states. So the aspect on financing arrangement that I said, as I said, is interesting because the investment costs are allocated between the states according to the benefits that can have from the management and the utilization of the waters. So the ONBS played a role for catalyzing the financial resources, but then the member states of OMBS, if they cannot reimburse the loans, they are the first responsible to pay back the loans received for the building of this water infrastructure. So as I said, we have these two agencies on the management and operation of the two dams, and they have different features. In particular, the Diama infrastructure is as a primary objective the sale of water, and we can see the specific role of the OMBS member states. That is also a feature of the SOGEM Convention on the Manantali Dam. And a difference between these two dams, it is that in the case of the Manantali, the first aim is the sale of electricity. So we can see some differences between the primary objectives of this two water infrastructure. And what is also interesting, it is that we have agreement on electricity price between the countries. So in the case of the Diama Dam, there is an important element related to the irrigation, and also this dam bring water to the urban and rural areas. While the Manantali Dam, it is more on the side to bring electricity. That of course we know that it is indispensable also to bring water. So here it is to give you an idea of the cost sharing key. It is quite old, 85, but states are negotiating a new cost-sharing key that also include Guinea. As you can see, it is not in this case included. And we can see that the cost allocation, the most part of the share is on the Senegal side. And regarding the allocation of benefits, as you can see, the irrigated agriculture represent the most part of the benefits received by Senegal, and in the case of Mali, there is the navigation. As we know, the Mali is a landlocked country, so the navigation, the access to sea, it is really important for this state. So we now go to the Niger watershed. And here we can see that we have two different types of infrastructure: the common work and the work of common interest. And so there are differences between the two infrastructure, as we will see. And in particular, as in the case of the Senegal, the common works are based on a legal act that are adopted by the member states of the Niger Basin Authority. And in the case of works of common interest, it is a facility that is not the property of all the states sharing the basin, but also a subset of them. So this is a difference between the two legal frameworks. And so there is a
you can just kind of move along a little quickly. We can get a few questions in before the end of the webinar.
So for I will give you an idea about the how the environmental and local community consideration are included in benefit sharing. We have the recognition of the right to water and public participation in the two charters, but it is more in the case of the Niger Basin Water Charter, where we have the recognition of the right to water. And here you can see the definition is taken from the general comment number 15. So there is also a clear inclusion of the civil society, and we have the local, the water users association that play a role in both river basin organization, and the two organizations try also to improve the conditions of the local community. Also, the environmental part, it is very strong in the two charters, in the two legal frameworks. And so the final remarks, it is really that we can see in the benefit of sharing an evolution from an interstate dimension to an involvement of local communities, and also a focus on the environmental protection. And so we can call this as an environmentalization and humanization of this legal regime that also incorporate not only states but also non-state actors. Thank you for your attention.
Well, thank you so much for that, Mara. That was a really in-depth. I'm sorry I had to push you along a little quickly there at the end, but we just are right up out of time, and I'd like people to ask a few questions in my panel before we get done. Quickly remind our audience that from a few questions that come in, that all these articles are available on the website. Go to Water International, just type Water International IWRA, and you'll go to our website and you can find the articles, and these and our others in the same journal issue. And so that's probably the best thing to do. Quick question for all of our panelists. Are there any examples, or what examples can you think of really effective water law applications that integrate surface and groundwater management on both legal and hydrological bases? I'm going to go ahead and leave this open for the panel. Anyone can answer. And please mute or unmute yourself. Speak.
Maybe I can try to answer. Or it is for a specific...
No, it's not for anyone specifically, just for anyone who can have an idea. The first
I suppose it might depend what the questioner meant by effective. So I can think of many examples where surface water and groundwater have been integrated. Certainly if we look at the European Union and implementation of the Framework Directive, and lots of states as a result of that have tried to recognise that hydrological integration and reflect it in the law, for example by bringing groundwater into the public domain, and therefore abstractions of groundwater would need to be licensed or regulated in a similar way to surface water. But that's not to say that's necessarily been straightforward. So there might still be lots of small abstractors with private wells and it's proved very difficult to bring them into that system. So as is often the case, getting the legal framework is one thing, but then actually implementing that and having both the regulatory effort and the stakeholder engagement to bring people on board and see why that has to be done, that's always where the challenge is.
Yeah, I would like to add about the UN Water Courses Convention, what also mentioned Laura. In 1994, there was the adoption of a resolution where there was the call from the International Law Commission to apply the same principles to surface water and groundwater resources. So I think it is very important to have an integrated approach on the management of the two typologies of water, if we can say.
Okay, I know a few of you in the audience have very specific questions for our panelists, and I would just encourage you to follow directly by email with the panelists. You can just Google their name, they'll come right up, and you can just drop a quick email if you have a very specific and detailed question. Another question that's come up from our audience is sort of, we've talked about a lot of different interesting, innovative ideas, but what are the sources of funding to implement these ideas? And if the source of funding is private corporation money, how do you alleviate those concerns amongst members of the public who very rightfully are concerned about privatization of water resources? I mean, if you don't build private money, I mean, what other sources of funding are there other than just state funding? So what are some ways to get money going into this to make these changes that we're talking about today?
Okay. Are you talking about privatization of water resources? I don't think this is a good idea, actually. The thing is that the key lies in, in the grant and on the issuance of long-term concessions to those willing to invest in water resources development, in water resources projects. Concessions which are not permanent, have a duration which is good enough to let the investor recover the capital invested, but are subject to conditions set by the authority in the interest of all. So I don't believe in privatization of water resources, in privatization of water services, I mean, in infrastructure. The service provider may be a private individual, a company, but subject to certain conditions. And of course, in the respect of what is set, for instance, nowadays in water resources plans.
Yeah, I would agree. I mean, the resource should be public, and I think one of the problems we're going to see over the coming decades is water grabs along with land grabs, which is about privatisation of the resource, and that to me is quite scary. In terms of service provision, it's all about regulation. Ownership matters, but not as much as regulation, and a well-regulated private sector. But we also need to regulate the public sector. So I think service provision, it's about regulation. Water resources must be in the public domain, and that needs to be protected with an eye to the long term.
Yeah, I think one has also to be very careful at the level in which the services are provided and regulated and controlled, because there's a trend nowadays to say, okay, river basin management, decentralization, let's decentralize, let's manage water resources by river basin, and let's consider services from a river basin perspective, when in many cases there's no capacity to regulate, no capacity to control, no capacity to deal with this issue. So this is a matter which needs to be considered very, very carefully. I can't hear anything.
You need to unmute your microphone.
Who's speaking?
Okay. Oh. So now I'm speaking. Helle is speaking, because I think additionally to what you have rightly put forward about privatization of the water resources, also the issue of privatization of the regulation of water, which is what is happening in Nicaragua, for instance, and in many countries in the same situation as Nicaragua, where the private sector needs this regulatory service, but there's not enough public funds to make that regulatory service, and so the private sector even funds that itself. Now that of course introduces a whole new bias in water regulation and in the governance of water resources that I don't think is in the broad public interest, and can become very, very dangerous.
Yeah, I can add the example of Madagascar. They've been trying to set up a regulator under, which is required under the water law, which is currently under revision, which has become actually a monster because it's now a law on water, sanitation and hygiene. and they want a regulator to deal with the whole sector of water, sanitation, and hygiene. And presumably they intend to basically decentralize the maîtrise d'ouvrage, the management of the services to the lower level, to the lowest level, which is not possible because A, there's no capacity, B, there's no infrastructure whatsoever, C, well, there's also the linkage between the lower level and the central level is a little bit blurry, is a little bit undefinable. This is very dangerous, I believe.
Maybe I would like to add also the investment dispute that we can have between government and in the private sector, and there are many cases, for example, related to Argentina. So it is also interesting to look at these different fields of international law, like international investment law, and to see also the linkages between economic law and human rights, because there is an increasing attention on providing access to access of water to the population.
Yeah, I mentioned earlier the case, case between Argentina and Chile, the Pascualama case, big mining company that takes possession of basically glacier water, moving it from one place to another, and the glacier actually feeds transboundary water resources, and this has a big impact on the communities, both in Argentina and Chile, and there's a big movement against this. Now the case is in court. So I believe there has been a judgment actually this year. The case has been brought to the Supreme Court of Chile.
Okay, well, I think we're kind of wrapping up here towards the end of the webinar, the end of our allotted time. So if anyone has any kind of final comments they want to make, or final ideas to engage here on this subject, or anything else we've heard about and talked about today, let's give everyone a chance to go kind of around in the same order that you spoke. So Sarah, do you have any final comments?
Just my thanks again to the organisers and also to the other presenters. It was really interesting hearing you talking about your work, and I hope to meet you in person again someday. Thanks.
And let me echo that.
Laura, Marcella.
Others? To conclude, to wrap up.
Thank you to the organizers and for all the presentations. Thank you.
Yeah, of course.
Scott, you've done a great job, really.
Yeah.
Yes.
Thank you. I appreciate those words. Sometimes a little stressful, but we got it all done. I'm happy to have you all here today. And I'd like to take this time to thank all my panel and everyone that came here today and helped us out, all your patience, all your help, and everything. So thank you to everybody, Marcella and Nanni from the International Association for Water Law, Sarah Hendry from the University of Dundee, Helle and Munk Ravnborg from the Danish Institute for International Studies, Laura Pateiro from the University of Vigo, and Mara Tignino from the Geneva Water Hub. All of you, thank you so much for coming today and helping us and making your presentations and contributing to Water International. I know here in the audience, a lot of you are on Twitter, and IWRA is on Twitter as well, and many of our panelists are on Twitter, so go ahead and look us up and follow us and keep engaging, keep this conversation going. As I mentioned earlier, we're going to have try to engage a little bit on the LinkedIn webpage. I'll be posting something here in the next day or two about kind of about the debates and discussions we had. So please, if you're in the audience or if you're one of the panelists, go onto LinkedIn and make a comment and kind of keep this discussion rolling. And I'd like to remind our audience that all these presentations do come from the special issue of Water International. So go ahead and go to our website, you can find Water International. It's our flagship journal, and look at all these articles and read really in-depth all the research and work that's being done here. And it's also going to be the subject of our forthcoming policy brief. If your time is a little more limited and you don't want to read 200 or 300 pages in an academic journal, then the policy brief at about 3 or 4 pages is maybe a little bit more your speed. It covers all the same topics. It just distills it right down to a manageable chunk. And so we're really looking forward to having that too. I'd like to just thank everybody and remind you all that if you found these insights about water law as fascinating as I did, you should really think about becoming a member of the International Water Resources Association. We are a membership-based organization, and so you can go to our website, www.iwra.org, and or just Google us, as everyone does, International Water Resources Association, and go and become a member today. We are an over 40-year-old nonprofit, non-governmental educational organization focused on bridging disciplines and geographies, connecting individuals, professionals, students, corporations, institutions, everyone who's really concerned with sustainable use of the world's water resources. So if you're interested in learning more, want to follow on, just go to our website, follow us on Twitter, stay connected, and we look forward to seeing you at our next webinar and staying with you as a member. So on behalf of the entire IWRA office, thank you for doing the webinar, and thank you for joining us today. Thank you.
Thanks, guys.
This was good.
Yeah.
Okay.